Hello, Ajay. Good evening. Good evening, everyone out there. So, the topic that we are going to start today is secularism. As far as the flowchart is concerned, I have already given you the flowchart in yesterday's lecture, right? So, today we are starting with the discussion on secularism as a topic, right? So, the first and foremost is what is the concept of secularism? Then what are the different models of secularism? As far as model is concerned, we are going to discuss three: US, France and India. Okay. Then we are going to talk about the contemporary issues. So what I have written under the concept is secularism is defined as a principle of separation of government institution and people who have the mandate to represent the state from religious institutions and dignitaries. It is devoid of both inter as well as intra-religious domination. It promotes equality and freedom both within and between the religion. It involves separation between state and religion. However, the nature and the extent of separation depends upon the values it intends to promote. That is why, based on the difference between this nature and extent of separation, you have different models, right? So once you've written this much, please let me know. लिखो आराम से. Done? Okay. So yeah, so based on the extent of separation between the state and religion, we have different models. So the first model that we are talking about is the US model of secularism. The concept of US model of secularism is given by Thomas Jefferson. It was said that the sphere of politics is separated from sphere of religion. State shall not adopt any religion as state religion. No one shall be discriminated based on the religion he or she practices. That is, the sphere of politics is mutually exclusive vis-a-vis sphere of religion. So in context of US, the model was given by the conception of US model of secularism was put forward by Thomas Jefferson, who said that the sphere of politics is separated from sphere of religion. The state shall not adopt any religion as the state religion. No one shall be discriminated based on the religion he or she practices, and the sphere of politics is mutually exclusive vis-a-vis sphere of religion. What it says when we say mutually exclusive, It means under no given circumstances, the politics would interfere in the matter of religion, that is, state will not interfere in the matter of religion. Similarly, under no given circumstances, religion will interfere with the state policies. That is, if you have two spheres like this is sphere of politics, this is sphere of religion. There exists an arm length distance. Arm length समझते? Whenever in your school life, your teachers were asking you to stand in a queue. So they used to ask you, maintain an arm length distance. Do you realize why the arm length distance? Because if you are maintaining an arm length distance, that you are no way in a position to interfere in each other's arena. So in order to avoid any conflict between the students, the teachers used to ask us, maintain arm length distance from each other. So that arm length distance means neither politics is interfering in the matter of religion, nor religion is going to interfere in the matter of politics. Is that very clear? So when we say, itna likh lo. So basically, in context of US, if I talk about, since state under no given circumstances is interfering in the religious matter, that means this model of secularism does not offer scope for state-supported religious reform, because no matter what is happening within your religion, whether you are being denied entry into some temple or some church, they don't care. They will leave the matter there and then. Is that very clear? Because it is being believed in this context that religion is your private matter. So the state should not have any say in your private affairs. Is that very clear? So the rationale behind US model of secularism is religion constitutes private affair. Hence, state shall not intervene. As a result, it offers limited scope, or let us say no scope, for state supported religious reforms. It doesn't offer the scope of state supported religious reform. So it has no scope for state supported religious reform. And it is believed, since religion constitutes your private matter, so it is not a matter of state policy or law. Hence, state will not intervene. In fact, in context of US, they interpret the equality and liberty with respect to individual. They do not offer any scope for community-based rights. Here, दिखेगा क्या? नहीं ना, यहां पे लिखो. Here, liberty and equality, these concepts within secularism, is interpreted with respect to individual. No scope for community rights. So minority community rights, they don't talk about that. They talk about the equality and liberty with respect to the individual. So this is what we have when we talk about the Western model of secularism. Done? The next that we have is the France model of secularism. The French model of secularism, I think we are done, right? So the French model of secularism is basically known as laïcité, which means secularity. Laïcité. It means secularity. The second model that we have is the France model of secularism. It basically discourages religious involvement in government affairs, specifically religious influence in determination of the state policy. So here also the sphere of politics is separated from sphere of religion. The state is not encouraging or supporting any religion, neither it is discouraging any. They are not interfering in your religious matter until and unless your practices and your beliefs are not interfering with the state or with other citizens' rights. So until and unless your beliefs and practices are not infringing upon or interfering with other citizens' rights and the work of the state, they will not interfere. However, since in context of France, there is commitment to complete separation, as a result, any explicit or overt expression of religious symbols or identities is prohibited in public space. Public sphere basically means public space, public school, and public offices. Once you've written this much, please let me know. Sricharan, it meant that in US context, community rights are not talked about. For example, in our constitution, we guarantee rights to the minority community, religious minorities. Community as a whole has a right to, practice and maintain their own religious institutions. So the state is not interfering. So we are not only guaranteeing the individual the freedom of conscience, that is the freedom to practice, profess, propagate their religion, but we also guarantee the religious minority communities also the right to maintain and, their religious institutions and practices. However, in context of US, they only give the right to the individual, not to the community. Is this very clear? In fact, there is one thing which is being said with respect to France as well as in context of US. But before I arrive to that point, let us just discuss. I told you in context of US, the rationale behind adopting the US model of secularism was because they believe it is a private matter, right? So it should not have any state law or policy which is, interfering in your religious world and vice versa. In context of France, the rationale why over the period of time they have started prohibiting or restricting the practice of overt expression has been that in context of France, there has been a history of church domination. So the rationale behind France adopting this model of secularism over the period of time has also to do with the history of the church domination. The church was all encompassing. It was omnipresent. Every aspect of the life of French society was governed by church, to the annoying of the king and the commoners. They didn't want that to happen. As a result, they wanted to tame religion. They wanted to domesticate religion. As a result, in context of France, what we have witnessed in past has been the process of secularization. This I have already referred when I was talking about fundamentalism. It's a process whereby the social significance of religion declines, and how that social significance of religion is declining through the process of differentiation and privatization. So through the process of differentiation and privatization, the social significance of religion declines, and because of which the concept or this model of secularism has been adopted in context of France. So what has witnessed or what is the rationale behind France adopting this model is that there was church domination. They wanted to curtail the authority of church. They wanted to domesticate religion. As a result, any explicit expression of religious symbols in today's France is not allowed. Is that very clear? Is it making sense? So एक line में लिखो. The US secularism is known as soft secularism. The US secularism is known as soft secularism, whereas in context of France, it is known as hard secularism. In context of France, it is known as hard secularism. The concept of French secularism was based on the rationale. The concept of French secularism was based on the rationale that they had the history of church domination. They had the history of church domination. Hence, to curtail the authority of church, any explicit expression of religious sentiments is prohibited in public sphere. Any Yes, Mitali. Any explicit expression of religious sentiments is prohibited in public sphere. Clear for everyone? Next, we have the Indian model of secularism. The concept is borrowed or inspired, let's put it this way, from Western origin. However, is rooted in its unique socio-historic circumstances. We were and are religiously pluralist society. Hence, we wanted to accommodate diversity. We wanted to ensure equal respect and space for all religion. And that is what we promised also during freedom struggle. As a result of it, the model of secularism which exists in context of India, as you might have studied in your polity as well, this is the model of state, this is the sphere of religion. It says that the wall of separation between the state and the religion is porous. That is, under no given circumstances, religion can interfere in the matter of state. No given circumstances, religion should interfere in the matter of state. Religion cannot influence the organization of society, institutions, state policies. Religion would not be influencing. So any mobilization of the vote bank on religious lines ideally is not allowed in context of India according to Indian model of secularism. Is that very clear? So the religion under no given circumstance can interfere in the matter of state. However, the state can interfere in the matter of religion. And why it can interfere in the matter of religion? First point, to give effect to the progressive voices within every religion and to disagree with certain aspects of religion. For example, abolition of untouchability. For example, abolition of triple talaq. For example, allowing women to enter Sabrimala. So in context of India, the wall of separation between politics and religion is porous. When we say it is porous, that means the religion can not interfere in the matter of state no matter what. However, the state can intervene in the matter of religion to give effect to the progressive voices within every religion and to disagree with certain aspects of religion. Because here we are not only looking at inter-religious domination, but also intra-religious domination. And by virtue of this provision, it creates the scope for state-supported religious reform. By virtue of this provision, it creates scope for state-supported religious reforms. Is this clear? Not only this, in context of India, the secularism deals with freedom of both religion as well as the freedom of religious minority communities. Write down one more line. In context of India, it deals with freedom of both individual as well as the religious minority community. So what, इतना लिख लो फिर बात करते हैं. So what exists in context of India, yeah. So what exists in context of India is not arm length distance, but the concept of principled distance. You've written this much? What exists in context of US was an arm length distance. What exists in context of India is the concept of principled distance. It's a concept given by Rajiv Bhargav. This concept says the state shall remain distant from religion so that it can intervene or refrain from interference depending upon what is advisable to uphold the values of equality, liberty, justice. This idea of principled distance is a good idea. I think who has asked this? Shivam, ma'am, isn't the concept of arm length distance is a need of the hour? In the current scenario, the way our politicians are using. See, that is the problem, that we are politicization of religion is happening. The problem lies with us. However, if you read the concept of principled distance, it's a very progressive concept. Just read it. That is why I was waiting to answer your question, Shivam. I wanted to write this down first. State shall remain at a distance. It will remain distant from the religion so that it can intervene or it can refrain from interference depending upon what is advisable to uphold the values of equality, liberty, and justice. On one hand, we believe that the arm length distance is required. As Shivam is saying, there has to be a strict separation. Why? Because otherwise the tyranny of the majority religion in the name of interfering with their practices, it is denying them the fundamental right to freely practice, profess, propagate their religion. So with respect to inter-religious domination, this idea of maintaining arm length distance is fine. But we can't afford to maintain that arm length distance, specifically in a country like India. Reason being, there are so many intra-religious practices which are existing, which are against the values of equality, liberty, and justice. If we haven't interfered, what was the status with respect to untouchability? If we will not interfere, then what is the status with respect to instantaneous triple talaq? Right? If we wouldn't have interfered, then women would not have been guaranteed the rights, the succession rights in their parental properties. So with respect to caste, with respect to patriarchy, that is to ensure women empowerment, with respect to incidences of fundamentalism which is emerging within certain religion, with respect to sectarianism which is emerging within the religion, that is formation of different sects. So there is intra-religious domination which is happening. So to curtail, because secularism talks about to deal with both inter and intra-religious secularism, right? So the idea of principled distance is not wrong. However, the manner in current scenario or in general it is being used for serving their political vested interest is definitely a challenge. Is there anything which I have not written on the screen? Where do you want me to slow down? Where? जब सब लिख लो तो मुझे बता देना। क्या बात कर रहे हो यार, मतलब डू नॉट गिव मी दैट नाउ। डोंट आई आस्क यू दैट वंस यू हैव रिटन then I start explaining? Am I not doing that now? Am I not asking you? जाके अपना तुम लोग रिस्पॉन्स पोर्टल क्यों नहीं पढ़ते हो यार? Guys, do you realize this is my second class as well? You have the option, you're sitting in your comfortable clothes, sipping tea, coffee, water. You can take break whenever you want because recorded lecture is being provided to you. This is my second lecture as well. I totally understand, but the point is ये एक्सरसाइज में करी क्यों रही हूं? अब देखो तुम ही लोगों ने डन लिखा है। मतलब क्या यार गजब करते हो भाई। Through this point, I was just explaining what किसने पूछा था? शिवम ने। What Shivam had asked before. ठीक है? So I was answering to the question which Shivam asked, that do you think arm length distance should be the need of the hour? So fine. With respect to arm length distance, that is maintaining a strict separation, it is fine in context of maintaining or ensuring that inter-religious domination is not there. One religion is not being pitted against another, and you are respecting their fundamental right to practice, profess, propagate the religion the manner they want to do it. That is, liberty with respect to religious conscience has been guaranteed. However, this concept of principled distance becomes important when we are dealing with intra-religious domination, right? Because there have been practices of caste discrimination, there have been practices of gender discrimination, there have been incidences of emergence of fundamentalism. So in order to curtail these incidences within every religion, that is, to give effect to the progressive voices, to give effect to the concerns of the marginalized section within every religion, this scope for interference has been created in context of India. So that is why the concept in case of India is principled distance. That is, the state shall remain distant so that it can intervene and it can refrain from interference depending upon what is the need of the hour, whether it is advisable to uphold the values of equality, liberty and justice. You can take the person out of their culture, but you can't take the culture and the lifestyle out of that person. Yes, I belong to Kanpur. Shweta, that's their prerogative. I can't comment on the fact that why they are not interfering. That is their prerogative. If there exists some unequal practices in certain societies, that they have to decide whether they choose to interfere or not. We have chosen that we have to accommodate the religious diversity, so equal respect for all religion, and we want to ensure that within every religion also equality prevails. So no one shall be dominated or discriminated within every religion. That's our take on it. In fact, okay, do you realize that every ideology that you develop is according to your leadership? Over the period of time when the leadership undergoes a change, it's not about our society, it's not about others, everywhere. Whenever the leadership undergoes a change, the manner in which the ideologies are being practiced also undergo a change. There was a time in context of France where there was a strict separation between state and religion. Even state was not interfering in any of your religious matter. However, all of a sudden in 1980s, a diktat was issued that the girls of a particular religion would not be wearing headscarf in their educational institutions. कुछ deja vu feeling आ रही है. So in France society in 1980s, 1989 to be precise, all of a sudden there was a diktat which was issued that the headscarves should be banned. And over the period of time that practice continued. Right. Before that, there was no such event which has happened. Till 1980s, everything was going very smoothly. In fact, the French secularism was acting in a similar manner as it was existing in context of US. Strict separation. However, post 1980s, it underwent a change. Was it over migration, in migration of the Muslim community in the French society? Was it the impact of Islamophobia that was emerging that time? So it could have been anything. So later it was found that Burkini ban came. So did you realize what it is actually happening? So it depends. Every country has its own set of understanding, their own set of ideology. Exactly. Exactly. Yes. Yes, absolutely, Mitali. And when their homogeneous fabric was getting disrupted, so slowly and gradually, why during the reign of Donald Trump, the protectionist measures were taken? Why they were taking protectionist measures? Because now their homogeneous society was also getting disrupted. That is one idea. And second, it was the ideology of the leadership that was existing that time. So it all depends upon that. What are the circumstances? What kind of leadership do you have? And what kind of perspective the leaders have? Is that very clear? Nahi, Sri Charan, they cannot be. They cannot be. Nahi. Na. Is this very clear? Can we proceed? Chalo. Write down a question. Write down a question. Discuss to what extent Western model of secularism, to what extent Western model of secularism is different from that of India. To what extent Western model of secularism is different from that of India. To what extent Western model of secularism is different from that of Indian model of secularism. A 10-marker question. It's a UPSC question. Can you write the answer? 2 minutes. Can you write the answer? To what extent Western model of secularism is different from that of Indian model of secularism? 10-marker question. It's a UPSC question. Fine, good enough. ठीक है, गुड इनफ। ठीक है, नेक्स्ट कॉन्टेम्प्ररी इश्यूज। एक बात मेरे को समझ नहीं आई, जब तुम लोगों ने ये पूरा टॉपिक कर रखा है पॉलिटी में, तो इतनी देर से हम लोग क्या बातें कर रहे हैं? तो ये बात पहले क्यों नहीं बताई? वाई हैव वी डिस्कस दिस? इट वॉज नॉट रिक्वायर्ड इफ यू हैव ऑलरेडी डन दैट। अगर ऐसा कुछ भी हो दैट यू हैव ऑलरेडी डन, प्लीज लेट मी नो। ठीक है, just one piece of advice, you might have done this as an assignment question. Just one thing, whenever you are writing a comparative question, just an idea, ठीक है, I think I've said this before also, try to give the parameters based on which you are going to compare. बस इतना ध्यान रखना। ऐसा नहीं है कि कोई हार्ड एंड फास्ट रूल है, इट्स जस्ट दैट इट एनरिचेस योर प्रेजेंटेशन, दैट्स इट। ठीक है, so it will enrich your answer, that is all. So let us say if I have to compare the two set of secularism, the Western model and the Indian model, one of the way of doing it could have been, you start with the concept of secularism. You can then talk about the rationale behind the emergence of different interpretation of secularism. Another, just saying. Then you can talk about the rights which are guaranteed under this secularism. Then you can talk about the extent of separation which is existing with respect to this secularism. Is that very clear? हाँ Sabeem, we can say. ओके अच्छा ठीक है, अगर ऐसा कुछ भी हो दैट यू हैव स्टडीड तो प्लीज लेट मी नो। ठीक है, तो फिर ये पढ़ रखा है ये बताओ पहले, यूनिफॉर्म सिविल कोड, ये पढ़ा होगा फिर। अगर सेक्युलरिज्म करा है तो फिर तो यूनिफॉर्म सिविल कोड कर रखा होगा। एक बार जल्दी से फिर देख लेते हैं, ठीक है, क्योंकि आई थिंक तुम लोगों ने कर रखा है। सो वेरी क्विकली, व्हाट डू यू मीन बाय यूनिफॉर्म सिविल कोड? एक लाइन में लिखो। इट रेफर्स टू the body of laws, it refers to the body of laws pertaining, it refers to the body of laws pertaining to personal matters, pertaining to personal matters, pertaining to personal matters. That is, it refers to body of laws pertaining to personal matters. That is, there will be a common set of laws. That is, there will be a common set of laws governing all of us. There will be a common set of laws governing all of us, irrespective of our religion, irrespective of our religion, in our personal matters, in our personal matters, irrespective of our religion, in our personal matters. And repeat, that is, there exists a common set of laws which will be governing all of us, irrespective of our religion, with respect to our personal matters, that is, marriage, divorce, succession, inheritance, adoption, etc. Marriage, divorce, inheritance, succession, adoption, etc. Next, Article 44 of, अच्छा नहीं, फिर बोलोगे फास्ट हो गई मैम Next, Article 44 of the Constitution guarantees, Article 44, ये लिखा है तुम लोगों ने, right? Article 44 of the Constitution guarantees the state shall endeavor to secure the state shall endeavor to secure for the citizens a uniform civil code throughout the territory of India. A uniform civil code throughout the territory of India. Now, 5 minutes. Let's do the debate with respect to Uniform Civil Code. Whether Uniform Civil Code should be there. So arguments in favor of Uniform Civil Code and arguments against Uniform Civil Code. And I want you guys to participate. You have 5 minutes. Please think, brainstorm karo. Or just one advice, hadbarahat mein do not start writing on the portal. Just think. What is Uniform Civil Code? Even if you've not studied and even if you've studied good enough, the point here is you know what is Uniform Civil Code. Irrespective of our religion, there would be a common civil code which would be governing us in our personal matters. तो चाहे marriage, divorce, succession, adoption, inheritance जो भी हो, तो फिर वो तलाक वलाक का इशू आएगा ही नहीं, inheritance का इशू आएगा ही नहीं, desertion of wife का इशू आएगा ही नहीं. जो भी religion के अपनी practices हैं, that would cease to exist. It is a common set of laws which will be governing each one of us irrespective of our religion. So there would be a uniformity. Now, keeping this understanding in mind, give me the arguments for the motion and against the motion. Do not look at the screen. Absolutely. Absolutely. Equality would be promoted. Done. Gender justice, gender biases, absolutely. Women empowerment, done. Perfect. Chaitanya, it will create a stiff between community and state and will make them anti. We can rather work, क्या लिखा है? Progressively. Absolutely. Chaitanya, I agree with it. That in order, because in today's time, this entire issue of Uniform Civil Code, I'm not explaining anything. नहीं, पहले तुम लोग लिख लेना. नहीं तो फिर बाद में बोलोगे हम लिख नहीं पाए. But yes, I agree with your statement, Chaitanya. I'll just get back to the statement while I'm explaining everything. I'll get back to that. Absolutely correct. Can be compromised. हाँ पारस बिल्कुल कह सकते हैं. Privacy will be violated. Adoption is secular. Hence it will not affect any religion. Brings gender equality. Perfect. Perfect, Weber. Perfect, Amit. Sejal. Helps in fighting against the regressive practices, right to life with dignity. Absolutely correct. Scientific temper, rational laws आएंगे. regressive practices would be done away with. It will reduce the incidences of vote bank politics. Absolutely correct. The court burden will be reduced. Absolutely, Abu. Yes. Bharat, absolutely. Yes, this is what I was looking for. I think someone has mentioned it before also, but this is absolutely a very good presentation. The complex religious, the regressive religious laws would be done away with. A sense of homogeneity. हाँ रवि कह सकते uniformity, sense of homogeneity. It would be easy. The burden on the administration would also reduce. It will reduce the incidences of religious conflict. So automatically the burden on the administration would be reduced. Mitali, perfect. Anshul, yes. इसको हम last में लेंगे, but I got your concluding remark. I wanted to write this. Thank you. This Priya, very good. Against me, it will dilute the essence of salad bowl theory of multiculturalism. When you aim at ensuring uniformity, so it has often been said, remember the last lecture we talked about, and I said that to ensure unity does not mean that you have to establish uniformity. All you need to do is you have to be accommodative of diversity. मैं ये सब dictate करा दूंगी, घबराना नहीं, ठीक है? Perfect answers. Most of you have written very nicely. Neha, very, very well articulated. Very well articulated, बच्चे. Perfect. Absolutely correct. Good. Very nicely written. Will encourage interreligious marriages. Okay. Good. Yes, so let's just look at it and see if we have missed out any point on the board. We'll add it. Yes, add against wale mein ek point. It goes against the salad bowl theory of multiculturalism. Add that point in against. I can't write anything. ये screenshot आज सुबह ही पढ़ाया था. So I took a screenshot कि शाम को भी पढ़ाना ही है. So just add one point. Salad bowl. It goes against the salad bowl theory of multiculturalism. Just add that. Against में add कर देना. So let me just read it out for all of us. So with respect to 4, right to equality with respect to personal matters would be guaranteed. It will help us realize the will of the constitution makers as mentioned under Article 44 of the Constitution, because they wanted to establish secure uniform civil code for all of us. So it will help us realize the will of the constitution makers by implementing or giving effect to Article 44 of the Constitution. What I meant with scientific temper was, it will enable us to do away with the regressive laws existing in every religion or in different religion and help us ensuring scientific temper. आपको बस sentence complete करना है. Absolutely, Niharika. It draws its legitimacy from the Constitution. Then it will ensure uniformity with respect to personal laws. It will reduce the legal burden. It will bring an end to the vote bank politics. It will reduce the incidences of religious conflict, thereby promoting national cohesion. Is that clear? However, against, first and foremost, we do not know what exactly constitutes uniform civil code. there is a lack of blueprint with respect to what constitutes uniform civil code. और इन पॉइंट्स को इसी क्रोनोलॉजी में लिखना, रीजन बीइंग वन आफ्टर द अदर द पॉइंट्स आर डिराइव्ड फ्रॉम द प्रीवियस वन. Lack of blueprint with respect to what constitutes uniform civil code, because of which it generates apprehension among the minorities that it is the imposition of the majority culture on them. Third, because of this apprehension, it will further escalate the religious conflict and will create the probability or the potential for incidences of communal violence. Most importantly, the politicians, the leadership is also not serious about the issue because of the sensitive nature of the issue. Secondly, women empowerment as one of the reason to implement uniform civil code is an over exaggerated argument. Why am I saying this is, अगर विमेन एम्पावरमेंट सिर्फ कुछ बॉडी ऑफ लॉज को लाकर हो जाता तो अब तक हो चुका होता. यू हैव डाउरी प्रोहिबिशन एक्ट, यू हैव डोमेस्टिक वायलेंस एक्ट, यू हैव सेक्सुअल हैरेसमेंट एक्ट. कुछ हुआ नहीं. It is still existing there. I've already told you, law only determines the direction in which society should move. It is actually the attitude, the culture, the value system which determines the direction in which society actually moves. Is that very clear? So saying that just by ensuring uniform civil code, women empowerment will happen, gender justice would be ensured, gender equality would be ensured, it is an over exaggerated argument. If you're so serious about women empowerment, gender justice, gender equality, that can be done by supporting religious reforms in different religion. हमने abolition of triple talaq कर दिया ना, without implementing uniform civil code. We have allowed women entry in the Sabrimala without dealing with this overall concept of uniform civil code, right? The point here is also we have given the right to adoption to the members of different religious community. If you've studied your Juvenile Justice Act when was amended in 2015, it has incorporated the provision with respect to the adoption by the people belonging to different religion. ठीक है, adoption is a personal matter. राइट, एंड वो चेंज भी हो गया और किसी को पता ही नहीं चला, बिकॉज दैट वॉज इनकॉर्पोरेटेड अंडर जुवेनाइल जस्टिस एक्ट विच डील्स विद दिस कॉन्सेप्ट ऑफ अडॉप्शन. राइट, मोस्ट इंपॉर्टेंटली हिंदू सक्सेशन एक्ट हैज अलाउड वुमेन द राइट इन देयर पेरेंटल प्रॉपर्टी, बट फॉर विच कोई यूनिफॉर्म सिविल कोड नहीं आया. The point which I'm making here is, every time when you present the case for uniform civil code, saying that it would lead to women empowerment is an over exaggerated assumption. Is that very clear? Law in itself does not guarantee empowerment. There has to be will, there has to be right kind of attitude and value system. And if we are so focused, if we are so dedicated to bring about women empowerment, it can also be ensured by supporting religion-specific reforms rather than implementing uniform civil code. This is just one argument which I'm making. Okay? It is not about whether वैभव, I will not answer बच्चे that. क्या बोलूं, करंट वरंट छोड़ो. Usually anything which is, let me put it this way, whether it is caste, whether it is religion, it is often politically motivated. So it is not about current, it is not about past. I've told you, remember that one statement, politics is like an enterprise and politicians are like entrepreneurs. बस सबको पता है क्या करना है, ठीक है ना? So every now and then politicization of this issue is happening. Is that very clear? Most importantly, let me just finish what I'm trying to say. Law Commission presented in its consultation paper in 2018, and it said that implementation of uniform civil code is not desirable. Neither it is possible nor it is desirable, specifically in the current context. Whatever is the current state of our society, it is not advisable, it is not desirable, it is not possible to implement uniform civil code. That is what Law Commission in 2018 has said in its consultation paper. Is that very clear? It has been said that, do you realize there are larger issues with respect to implementation of uniform civil code? The problem doesn't lie with the idea of uniform civil code. The problem lies whether the society is mature enough. Just listen to me for once, ठीक है? क्योंकि फिर क्या हो जाएगा, disconnect हो जाएगा conversation. So the idea with respect to uniform civil code is, Ideally, we should have seen this concept of uniform civil code from the lens of what? Equality, right? Gender justice, okay? Why gender justice? Overall justice. So equality, liberty, justice. From this prism, the idea of uniform civil code should have been seen. But how are we seeing uniform civil code? From the prism of religious differences. Majority is happy that if uniform civil code gets implemented, it is our culture which is going to dominate. Minority is getting apprehensive. If uniform civil code gets implemented, it is our culture which is going to get dominated. The reality is neither majority nor minority actually knows what constitutes uniform civil code. What was the purpose behind implementation of civil code? We are not making them realize कि सुनो भाई, uniform civil code is not have to be seen from the prism of religion. It should be seen from the prism of progressive laws. It should be seen from the prism of equality. It should be seen from the prism of liberty. It should be seen from the prism of social justice. हम किस prism में देख रहे हैं? भाई जी religion है हमारा. तो आर यू गेटिंग द पॉइंट? आप उस चीज को गलत पर्सपेक्टिव में दिखा रहे हो, इसीलिए वो गलत पर्सपेक्टिव में उसे समझ रहे हैं. दैट इज द प्रॉब्लम. इसीलिए आवर सोसाइटी इज नॉट मैच्योर इनफ दैट वी कैन इंप्लीमेंट, वी कैन टेक दैट रिस्क ऑफ इंप्लीमेंटिंग यूनिफॉर्म सिविल कोड. Is that very clear? There is problem of cultural chauvinism. Finally, Vaibhav, I'm using your logic here. So there is a problem of cultural chauvinism. Everybody believes their culture is superior. So they don't want to feel deprived when their religion, the specific personal laws would be taken away, because there is a feeling of cultural chauvinism, and that's not a positively connoted term. You are not just taking pride in your religion, you are trying to superimpose the domination of your religion over others. So there is a problem of cultural chauvinism. The problem lies with the education system. Our education system is so ideologically colored, it is so religiously divisive that we are not able to create the youth who has the scientific temper. To be very honest, I am not saying anything with respect to hijab controversy right now. Nothing with respect to that. But the scenario which was there when there was a group of boys who were chanting certain slogan again against a girl who was wearing a burqa, and that was the scene which was being created yesterday, that is not a very civilized scene to be said. It is not about which religious community doing what. No, absolutely not. The question here is, what kind of youth are you creating? This youth is going to be the future of our nation, right? And what kind of youth are we creating? They don't even know the purpose. वो कह रहे हैं हम इक्वालिटी की बात कर रहे हैं, उनको यही नहीं पता कि किस कॉन्टेक्स्ट में इक्वालिटी. कभी संविधान उठा के पढ़े हो, देखे हो उसमें क्या लिखा है? So the point which I'm trying to make here is, the problem is we as a society is not mature. Problem doesn't lie with uniform civil code. Problem lies with us. We are not able to interpret, perceive the right intent behind uniform civil code. That is the problem. We are not prepared for it. We have a problem of lack of rational education. We are not a secularized society. Secularism only exists in a political domain. Our society still is not secularized. What we eat, what we breathe, what we wear, whom we talk, whom we marry, everything is determined by our religion. So we are not at all in the capacity of a secularized society. Is that very clear for everyone? For us, religion is not just a matter of faith. For us, our religion is our way of life. So when we are so overly driven by our religious sentiments, we are not prepared for the implementation of uniform civil code. Is this very clear for everyone? लिखो, एक दो पॉइंट्स लिखो. The challenges we are confronting, कुछ तो challenges ये हैं कि भाई blueprint नहीं है, apprehension है, political will नहीं है, ठीक है? These are some of the challenges. Next, right? According to Law Commission, Uniform Civil Code, that is UCC, is neither necessary nor desirable. At least in the current context. It is neither necessary nor desirable. Next. one of the challenge with respect to UCC is, one of the challenge with respect to UCC is, instead of being viewed from the lens of, instead of being viewed from the lens of progress, empowerment, justice, equality, etc., instead of being viewed from the lens of progress, empowerment, justice, equality, जो लिखना हो, liberty, जो लिखना हो, etc., it is being seen from the prism of religious difference. It is being seen from the prism of religious difference. Next. Lack of secularized society. Lack of secularized society. Lack of secularized society. Next. Lack of secularized society. एक तो सेक्युलराइज सोसाइटी नहीं है, दूसरा वी आर नॉट सीइंग द इश्यू ऑफ यूनिफॉर्म सिविल कोड फ्रॉम द राइट लेंस. Then Law Commission has also talked about why it is not necessary and desirable. Then problem of cultural chauvinism. Problem of cultural chauvinism. Politicization of religious issues. Politicization of religious issues. Politicization of religious issues. Lack of education based on scientific temper. Lack of education based on scientific temper. Lack of education based on scientific temper. एक कंक्लूडिंग रिमार्क लिखो. Democracies can be established in those countries. Democracies can be established in those countries which are multicultural. Democracies can be established in those countries which are multicultural. Democracies can be established in those countries which are multicultural. However, efforts should be made, to end the cultural exclusion. Efforts should be made to end the cultural exclusion. Development of complementary identities. Development of complementary identities and promotion of unity in diversity. Promotion of unity in diversity. Promotion of unity in diversity. Full stop. I'll repeat it again. Democracies can be established in those countries which are multicultural. However, the efforts should be made to end the cultural exclusion, develop complementary identities, and promote unity in diversity. Last point. National cohesion does not require imposition of common identity. National cohesion does not require imposition of common identity, but accommodation of diversity. Hence, any decision with respect to Article 44 should be on the basis of popular consensus. Any decision on the Article 44 should be on the basis of popular consensus. See one thing. It is not we who are saying whether Uniform Civil Code should be implemented or not. Okay. That has been the perspective of the Law Commission, that right now we might not be prepared because there are certain problems which are existing. Okay. The communal conflict, the incidences have increased in the current domain. At this point of time, in the backdrop of social media, any one aspect will have a significant snowballing effect. A controversy which started from one particular educational institution in one particular arena or one particular state has within a span of time become the national controversy. That is the impact of social media. Is that very clear? So in the current context, in the backdrop of social media, in the backdrop of rising aspirations of the youth, in the backdrop of growing economic uncertainties, when people are driven by their religious identities, the matter on Uniform Civil Code is sensitive. That is what I'm saying. I'm again reiterating myself. First of all, it is not saying that you should not implement Uniform Civil Code. It is saying, first of all, develop a blueprint. Right? Give the clarity to all the religious community, what is the idea behind Uniform Civil Code, how it intends to promote equality, liberty, justice, etc. Tell them how it is not the imposition of majority culture on the minorities, how the strengths, the good points of all the religion would be taken note of and the weaknesses would be done away with. Put that blueprint on the public platform for various deliberation, discussion and discourses, so that the people whose personal laws you are going to amend, they feel involved. Remember, I don't know whether I've discussed in your class or not, every individual is driven by two set of values. One is their core value. Other is their peripheral value. Okay? Just listen carefully. Every individual, whosoever we are driven by two set of values. One is our core value. Other is the peripheral value. Whenever you try to change someone's peripheral value, it is easily changed, right? But the core values, the core beliefs are very difficult to change. And the matter related to your religion constitutes your core belief. So if you are going to impose changes on it from above, there would be resentment. So it is advisable that you should make the people feel involved. They should feel as if they are able to exercise their right to self-determination. They should feel involved. And then the decision should be taken. This is what I am trying to say. Is that very clear? The parent generation is more religiously influenced and hence socialization of children is not done correctly. How to tackle this? How to tackle this? I don't know. It's very difficult to change the value system of your parents at a certain age. Take now. Obviously, they are 50s, 60s, whatsoever is their age. So it is difficult to change their value system. But yes, every now and then, telling them that this is right, this is wrong, and providing them the rationale. Maybe not today, maybe not tomorrow, but over a certain period of time, they might become slightly flexible. And maybe they are open to change. Do not expect change to happen overnight. Okay? Be the change you want to see in the world. First, you start practicing what is desirable. You become the example. Okay? Walk the talk. What you are preaching, you should practice it yourself. Automatically, it will have a snowballing effect. Maybe your parents also get influenced by that and they also try to mend their value system, which has been regressive over a period of time. Is that clear? That's one way of doing it, right? ठीक है, can we proceed now? We'll just take 5 minutes break. I need the charger. The system will close down. So just give me 5 minutes. नहीं वैभव, पॉपुलर कंसेंसस मतलब द कंसेंसस ऑफ ऑल द रिलीजियस ग्रुप्स, दैट इज व्हाट आई मेंट. ये थोड़ी ना कि 50% लोगों ने कंसेंट दे दी, पता चला 50 के 50% एक मेजोरिटी रिलीजन को बिलोंग करते हैं. नहीं नहीं बच्चे, आई एम नॉट सेइंग दिस. वील जस्ट टेक 5 minutes ब्रेक. आई जस्ट गेट द चार्जर. First question. UCC is a much needed step for India to move forward in the 21st century. Critically analyze. The second question is discuss the possible factors which inhibits the government to implement uniform civil code. The factors which is restricting the government from implementing uniform civil code. This is the UPSC question. It was asked in GS paper 2. I think 2015 या 16 की बात है, 12.5 नंबर का क्वेश्चन था, 200 वर्ड्स लिखने थे. Discuss the possible factors which inhibits the government to implement uniform civil code. Can we proceed? Rahul, just try doing it once. एक बार लिख के देखना. Just try it once, then we'll discuss. What I have written on the board. I've written Doctrine of Essential Religious Practice. This doctrine has emerged in Shirur Mutt case of 1954. It was a 7 judges bench case. It said that the term religion includes all the rituals and practices integral to the religion. In fact, it also said that even dress can constitute an integral part of the religion. This doctrine was evolved to protect those practices which are considered integral to any religion or essential for that particular religion. In fact, in this case, it was stated that the court will determine what constitutes essential religious practice. However, this has been the bone of contention because in various subsequent judicial pronouncements, it has been cited that court should not determine what constitutes essential religious practice. Otherwise, it would be termed as an act of judicio-papism. इतना लिख लो फिर बात करते हैं. डन. चलो. Let's start. See, it has been said, I think you guys have mentioned that you've done some aspect of, I think you've done this in detail, doctrine of essential religious practice. I think some was writing. But let me just revisit it. If you find any new point, you can add it to your understanding. And if it is the same similar points, then treat it as your revision. क्योंकि मेरे लिए फिर उसे break करना बहुत मुश्किल हो जाएगा. तो I will teach everything. ठीक है. So the point here is that see, Article 25 of our Constitution says that we have been provided the religious freedom, the freedom to practice, profess, propagate the religion of our choice. However, this right is not an absolute right. It is subjected to certain restrictions. There are three criteria: public order, morality, and health. ठीक है. Now it is being said that the state has a right to interfere with this religious matter, with the matter of religious freedom. And if the state has right, then to what extent? So the first thing, if your religious practice is interfering with public order, morality and health, definitely the state has the right to intervene, no matter whether it is essential or not. It doesn't matter in that context. However, if that practice is not interfering with these three aspects, that is public order, morality and health, then whether the state can interfere or not depends upon whether the practice is essential or not. So the state can intervene in only those practices which are not essential. The state cannot intervene on reasonable restrictions in the matter of those practices which constitutes an integral part or an essential part of any religion. Is that very clear? So a doubt may arise that if your essential religious practice is going against public order, morality and health, can state intervene? Yes. No practice should go against these three aspects. So whatever religious freedom has been guaranteed to you, it is subjected to these three things: public order, morality, and health. So even if it is a core practice of your religion, but it is going against any of these aspects, then the state has the right to intervene. However, let us consider public order, morality, and health is not getting challenged. Now, apart from that situation, in that situation, the state can intervene in only those practices on grounds of any reasonable restriction or reasons, provided those practices don't constitute the essential religious practice. That's first thing. Now the question arises, which practice is essential, which is not, and who's going to determine? So the very first case in which the doctrine of essentiality had emerged. So in Shirur Math case, it was clearly specified that the court will have the right to decide whether that practice is essential or not. However, in various other judgments, for example, it was the Santhara case. I'm just giving you an example. It was one of the cases, that is Nikhil Soni versus Union of India case. It was the PIL which was filed in Rajasthan High Court, and when the case was being taken, so Rajasthan High Court has banned the practice of Santhara, and it said that Santhara doesn't constitute essential religious practice. Hold. So when the PIL was filed by Nikhil Soni in Rajasthan High Court banned Santhara. Rajasthan High Court said right to life does not include right to die. Santhara is nothing but suicide. So basically Rajasthan High Court equated Santhara with suicide. And they also put forward the argument that it does not constitute essential religious practice. Hence we can intervene and we can ban Santhara. However, the judgment was challenged in Supreme Court. This was the judgment which came in 2015 and it was being challenged. So Supreme Court in 2016 lifted the ban. And it said that High Court made an error in interpreting Jain practice. Jain scholars were not consulted by High Court. Court should not decide on its own whether practice is essential or not. If the court does that, it's an act of judicio-papism. I'll repeat this. Judicio-papism consists of two words, judiciary and papism. Judicio is judiciary, papism comes from pope. This means over interference of judiciary in religious matter, judicial overreach. So there is a term which is used, judicio papism, when judiciary over intervenes in the religious matter. So that is judicio papism. So the court said that court can interfere in those matter which are not essential, but court shall not decide which matter is essential and which is not. If it does, it's an act of judicio-papism. Obviously, you can arrive at a conclusion whether the practice is essential or not based on the inputs from the Jain philosophers, Jain scholars, or the scriptures, or with respect to any religion, okay, for that matter. But you will not decide on your whims and fancies, on your personal beliefs, whether it is an essential practice or not. Is this very clear? Is it making sense? Okay. Then it said, last point, that you cannot equate santhara with suicide, because suicide is something which is impulsive. It's an individual act. Whereas santhara is not impulsive and it is done after much deliberation. Not everyone is allowed to practice santhara. There are certain conditions which needs to be fulfilled in order to practice santhara. Either you should be very old, or you should be terminally ill, or you believe that you have committed a sin and you want to pay for your sin by giving up on your life. So there are certain criteria which have been put forward so as to practice santhara. Not everyone can do that. So you cannot equate. It is an erroneous assumption when you are equating santhara with suicide. That is what Supreme Court said. Right? So this is what it is, right? So I was just trying to give you an example that how through subsequent judicial pronouncements it was identified that you can interfere in a matter which is not essential, but do not decide on your whims and fancies that what matter is essential and what is not. If you do that, then that is an act of judicio-papism. Is that clear? Nahi, Tanvi, it's a separate topic, bache. It's a separate topic. Essential religious practice. Is this clear? I wrote this example just कि फिर dictate नहीं करना पड़ेगा. लिख लो तो मुझे बता देना. There have been other cases as well. For example, एक केस आया था आनंद मार्गी केस. अरे संथारा, I wrote ना, संथारा is thinning out, voluntarily giving up food and water so as with the purpose of ending the life. Judicio-papism, बच्चे, judiciary का over interference in religious matter. That is judicio-papism, Shantanu. Judiciary, when overstepping their jurisdiction and entering into the arena of religion, that is judicio-papism. अरे यार judicial overreach लिखते हो ना, उसी में जब judiciary is intervening, overstepping its jurisdiction in area of religion, that is judicio-papism. वो court should decide. अच्छा, okay. Court should decide whether मैं बोल गई थी, मैंने लिखा नहीं था. द कोर्ट, नहीं सॉरी, मैं बोल कुछ और रही थी और मैंने लिखा कुछ और है. एक सेकेंड. हाँ, कोर्ट शुड नॉट डिसाइड वेदर अ प्रैक्टिस इज एसेंशियल और नॉट. इन केस इट डज, इट्स एन एक्ट ऑफ जुडिशियो-पैपिज्म. ठीक है. सो आई सेड कोर्ट शुड नॉट डिसाइड whether the practice is essential or not. If it does, then it's an act of judicio-papism. Court should not decide whether the practice is essential or not. If it does, it's an act of judicio-papism. और उसके नीचे लिखा है संथारा should not be equated with suicide. Santhara should not be equated with suicide because suicide is an impulsive act. Suicide is an impulsive act which is committed in an individual capacity. It's an impulsive act which is committed in an individual capacity, whereas santhara is practiced after much deliberation. Santhara is practiced after much deliberation. Just for your convenience, you can write, there are certain conditions which needs to be fulfilled before practicing Santhara. There are certain conditions which needs to be fulfilled before practicing Santhara. Take. I hope everybody has written this. वी हैव मोर एग्जाम्पल्स. अब जैसे मैं एक एग्जाम्पल बोल रही थी आनंद मार्गी सेक्ट का था, तो उसमें आनंद मार्गी एक सेक्ट है, तो उसमें क्या होता है, तांडव परफॉर्म करते थे लोग पब्लिक स्ट्रीट वगैरह पे, ठीक है. सो इट वाज सेड द कोर्ट गेव द जजमेंट एंड दैट केस इज नोन एज आनंद मार्गी केस, एंड इट वाज सेड दैट परफॉर्मिंग तांडव ऑन पब्लिक स्ट्रीट as in public space is not constituting the essential religious practice, and hence it was being banned. So when a practice is not essential, then the state has the right to intervene. So that is, it happened. Similarly, there was a case saying azan on the loudspeaker. So they said that saying azan is an essential practice, but saying azan on the loudspeaker doesn't constitute essential religious practice. Hence, it was being banned. Is that clear? Okay. Similarly, there was another case, that is Shaira Bano case. The Shaira Bano case, there were three issues which were raised. One was polygamy, other was talaq-e-biddat, that is instantaneous triple talaq. That is saying those three words talaq in one go. Is that clear? So there was Shaira Bano case which said about polygamy, triple talaq and nikah halala. However, when the court gave the judgment, that judgment was with respect to triple talaq only. The court did not intervene in polygamy and nikah halala. The reason was it was being cited by the court that instantaneous triple talaq, that is talaq-e-biddat, is considered as a sin even in Quran. Even in Quran, it has been discouraged that one should not give talaq-e-biddat. There is another concept, that is talaq-e-sunnat, in which the word talaq is being uttered over a period of time, that is subsequent 3 months. So those words are said in subsequent months, although it is being uttered 3 times only. So when the 3 menstrual cycles are completed, so in 3 subsequent cycles it is being uttered. That is talaq-e-sunnat, right? Then it is said that talaq-e-biddat is instantaneous triple talaq and it is considered sin even in Quran. So some practice which is discouraged in your holy scripture cannot constitute the essential religious practice. Hence the Supreme Court intervened and was declared that talaq-e-biddat, that is instantaneous triple talaq, was declared null and void. Is that very clear? And further, that was the jurisdiction of the court. The court said talaq-e-biddat needs to be banned. However, the government went ahead in order to protect the rights of the Muslim women with respect to the marriage. The Muslim Women Protection Act 2019 was put forward. Is that very clear? ठीक है. हाँ बच्चे, हाँ तन्वी, all of it that we are discussing now is an example of ERP. Right. So the government has come ahead with the act, and that act was basically the Muslim Women Protection Act. Right. Let's continue from here. Is it clear for everyone? Okay, can we proceed? So what was the act saying? Talaq-e-biddat. The act said Talaq-e-biddat is declared null and void. It is banned. Not only this, the offense was considered a criminal offense. If the husband is giving talaq-e-biddat, it is a criminal offense with 3-year jail term along with the fine. According to the act, the offense is cognizable if the information is provided by women herself or any of her blood relative. The act provides for the provision of subsistence allowance as well as the custody of the child. However, how much allowance to be given would be decided by the magistrate. Next, the issue is compoundable, as in without going through nikah halala, the couple can get back together if they agree to stop the legal proceedings. If agree to stop legal proceedings. Next, the bail will be granted only after hearing wife. This is the act. Muslim Women Protection of Rights on Marriage Act. Muslim women See, they did not dealt with polygamy and nikah halala because they could not establish the fact that whether it constitutes the essential religious practice or not. Actually, what is nikah halala? See, nikah halala was mentioned to discourage people from getting involved in talaq-e-biddat, because it says that if in a moment you have given instantaneous triple talaq and you want to get back together, the husband wife again, then they have to go through a process of nikah halala in which the wife has to marry someone else, consummate the marriage, divorce should take place, observe 90 days of iddat, and then can marry the same husband. Did you get the point? So it was believed that nikah halala was actually meant to discourage men from getting involved in this act. Below magistrate, subsistence allowance. Subsistence allowance plus custody, however, the allowance would be decided by the magistrate. Subsistence allowance. And then I have written the offense was considered compoundable, that is without going through the process of nikah halala, the couple can get back together if they agree to stop the legal proceeding. If they agree to stop the legal proceeding. Can we proceed? I give you 5 minutes. Can you do the analysis of this act? You might get a question with respect to the analysis of this act. Can you do the analysis, very quick analysis of the act? The positive and the negative of the act. Let us assume you've not studied anything, but just by going through the provisions of the act, what is the positive thing about the act? Just let me know if you've written this much. I just read out. For it served the purpose of stringent law to discourage the arbitrary practice. It created grounds for gender justice. Since it didn't constitute the essential religious practice, it was constitutional for state to intervene. It has the provision for redressal for women in the form of subsistence allowance and custody. It also acted as a means of deterrence. However, absolutely, the plight of Muslim women. So it has created the potential for gender justice. It has provided them the means of redressal of their grievance. It is acting as a medium of stringent law to discourage this arbitrary practice. It will act as a source of deterrence. Absolutely, all of this is there. Okay. It will ensure the life with dignity. You would not be at the whims and fancies of the other, as in your partner. So it would ensure with dignity. So in this capacity, it is a very progressive step. However, criminalization of civil offense. Divorce is a civil matter. You can't criminalize. Similarly, there is a problem of selective criminalization. ऐसा तो है नहीं कि Hindu community में there doesn't exist the practice of desertion of wife. There are a lot of husbands who, without divorcing their wife, have completely abandoned her, have completely abandoned, deserted the wife. In fact, one of the survey I was reading, I was going through this article in Hindu, it said that approximately 20 lakh Hindu women have been deserted, abandoned by their husbands without giving them the divorce. डिवोर्स होगा तो एलिमनी देना पड़ेगा, आपने अबैंडन ही कर दिया उनको, डेजर्ट कर दिया, राइट? एंड इन आवर सोसाइटी इट बिकम्स वेरी डिफिकल्ट फॉर अ वुमन to then sustain herself. Similarly, there are other religious communities also where there is this practice of desertion of wife, right? However, there has been selective criminalization. So on this ground, few of the people have criticized this act. It has been said that you have added, first of all, you have criminalized a civil offense, then you have provided for the concept of allowance, right? It would be very challenging. Anyway, Sachar committee report has been talking about, if Sachar committee report has been talking about that how Muslim, the status, the economic status of Muslims are even dilapidated as compared to SC/ST community, right? So how would it be possible for a Muslim male to provide for the subsistence allowance when he himself is in the jail for next 3 years? Most important aspect which was being criticized is when the court has said that instantaneous triple talaq is null and void. That means divorce has not taken place, right? That means that women continues to be married to that man, right? So now the problem is that when divorce has not taken place, then for what has he been punished? The problem, there were few of the intellectual communities, there were few of the people who were dissenting with this act, and they said it was absolutely fine till the time it was declared null and void. Because the moment you are uttering those 3 words of talaq and you are giving that instantaneous triple talaq, it is null and void. So whether you say it 3 times, 13 times, 36, 300 times at one go, the divorce has not taken place, right? And even if any third party is trying to proclaim that the divorce has taken place, right? So then that person would be penalized, as in you can charge some fine, or if that person is some Maulana or something, then their registration can be cancelled. So these practices could have been done. But the point here is divorce तो हुआ ही नहीं. अब क्या हुआ कि husband चला गया जेल. Now, anyway, Muslim women are not able to sustain themselves, right? Who would take care of the women? Who would take care of her children? You have said the allowance would be given. How the Muslim male will ensure allowance when he himself is in the jail? Then when he is coming back, do you really think he would not have any vendetta? He would not have any revengeful orientation towards that women. Maybe after that, the incidences of divorce and abandonment will further increase. This time he will not utter those 3 words talaq and he will just abandon the wife. तब तो आप उसे जेल में नहीं डाल सकते ना, तलाक नहीं बोला उसने, छोड़ दिया ऐसे ही. Are you understanding? You need to understand the broad reality of the social context in which we are living. Although this act does create the potential, but it has certain challenges which also needs to be looked. Is that very clear? Is this very clear? विनीत, इसका क्या जवाब दूं मैं? क्या जवाब दूं? How many cases would have been where Hindu woman has left her husband without any information in a society like India? How many cases? खुद सोचो. ठीक है. Next topic, let's take up very quickly Sabrimala. We'll start with Sabrimala. So what is Sabrimala issue? It is with respect to ban on entry of women in the menstruating age group in Sabrimala temple. Sabrimala, with respect to ban on entry of women in the menstruating age group in Sabrimala temple. Supreme Court in 5 judges bench case has lifted the ban. So it has granted women of all ages the right to enter the Sabrimala temple. It was actually the Indian Young Lawyers Association versus State of Kerala case. So Indian Young Lawyers Association versus State of Kerala case. Now, it has further been referred to a larger bench. Now, let's see कब result आता है, judgment आता है. So, as of now, this is the current state that the ban has been lifted. So, this was the judgment which was given by these 5 judges bench, and the judgment was given in 4:1 majority. There was one judge who was dissenting, and she was Indu Malhotra. Now, you must be wondering, why did I write this? I wrote this because, again, it is a very controversial issue. So whenever there is any controversial issue, I do not give my personal opinions. Okay, so we would be restricting to the debate as it has been put forward by these judges. So with respect to Sabrimala issue, whether women should have been given the entry, if they should be given entry, I am quoting the views of these judges. And when I am quoting that they should not be given entry in the temple, I am quoting the perspective of Indu Malhotra. Is that very clear? Is this clear? ठीक है. So इतना लिख लिया तो फिर आगे बढ़ते हैं. just few aspects. See, Sabrimala is the temple of Lord Ayyappa. Okay, so every religion, every temple, every religious place, they have their own set of folklores, traditional stories, right? So traditional tales, to be very precise. So with respect to Lord Ayyappa, there was a story which said that there was this one female, her name was Malika Puratamma. She was being cursed once and she was transformed into a demon. And that demon fought with Lord Ayyappa and was defeated. Okay. So when that demon died, there emerged a very beautiful woman and her name was Malika Puratamma. So Malika Puratamma was relieved of her curse and as a result she wanted to devote her life to Lord Ayyappa. ये सब लिखने का जरूरत नहीं है, ठीक है? So she wanted to devote her life to Lord Ayyappa. She wanted to marry Lord Ayyappa. So Lord Ayyappa said, the day first time followers will stop visiting me, I will marry you. First time followers as in the new followers will stop coming to me, I will marry you. That day never came. As a result, Lord Ayyappa did not get married to Malika Puratamma. However, Malika Puratamma, out of her love for Lord Ayyappa, remained unmarried all her life. So it is the Sabrimala temple where Lord Ayyappa has manifested himself in the capacity of a brahmachari, that is a celibate. So in order to respect his celibacy, in order to avoid any kind of distraction, it is being said that the women in the menstruating age group is not allowed to enter the vicinity of Sabrimala temple. Is that clear? It has been said there are thousands of temple of Lord Ayyappa. It is only this temple, that is their Sabrimala temple, where the women in the menstruating age group is not allowed to enter. The reason being is that the God himself has manifested him in a capacity of a celibate. So in order to respect his celibacy, in order to respect his privacy, in order to ensure no distraction happens, the women in the menstrual age group themselves don't enter the vicinity of the temple, and slowly and gradually over the period of time it has now become a practice. Is that very clear? However, a case was being filed, interest litigation, PIL was being filed, and said that it goes against Article 14, 15, 17, 25 of the Constitution. Hence, women should be allowed the entry, irrespective of their age. Is this very clear? Now the question arises that whether putting this ban on the entry of women constitutes essential religious practice or not. Is that very clear? Okay. However, while giving the judgment, it was being said, there were two set of judges. So the judges who had supported this idea that the ban should not be imposed, they said that this is nothing but the practice of patriarchal belief. One. Second, they said that if you want to protect the rights, the fundamental rights of the individuals have to be protected. The Lord or the deity or the idols do not have fundamental right of privacy, right? So that doesn't needs to be protected. Moreover, any ban which is there on biological or physiological reasons, that is the menstruation aspect, it goes against the principles of Article 14 and 15. And not only that, by restricting women in the menstruation age group to enter the vicinity of the temple is also like practicing untouchability under Article 17. I'll make you write everything, just listen. Under Article 17, right? So on this argument, Indu Malhotra dissented, and she said that when Article 17 was incorporated in the Constitution, it was with respect to the caste-based untouchability. You cannot widen the ambit of any article on your whims and fancies. So it was always on the basis of caste discrimination. The ambit cannot be extended to women. That is what Indu Malhotra said. To which the majority judges further argued and said that our constitution is not a static document. They applied the doctrine, that is doctrine of living tree. And they said our constitution is not a static document. It is ever evolving document. So as in when and how the society is progressing, we can widen the ambit of our constitutional provisions. So we have followed the doctrine of living tree in this context. This was being said. Is this very clear? Then Indu Malhotra also talked about that you need to understand that religion constitutes the core belief. The people who believe, who worship Lord Ayyappa, their women would anyway not enter the premise because they believe that it is only this temple where the God has manifested himself in the celibate capacity. So we need to respect his celibacy because we worship him. So those who worship him, those who believe in him, anyway would not follow. This is what Indu Malhotra said. However, the counter argument was that in the name of worship, in the name of a practice which is being existing, you cannot deny women the right to equality with respect to practicing the religious or the religion rituals or the practices. Any kind of discrimination cannot happen between men and women when it comes down to worship their or practice their religion, because that is the constitutional right which is being guaranteed to them. Is this very clear for everyone? Then also the majority judge said that it does not constitute essential religious practice, to which Indu Malhotra said, you cannot decide on your whims and fancies whether this constitute an essential religious practice or not. This is an act of judicio-papism. More importantly, Indu Malhotra also said that you need to understand that diversity does not equate with discrimination. Every religion has its own customs and practices. Similarly, Sabrimala temple also has its own customs and practices. What is being observed in context of Sabrimala is not discrimination. It is a certain form of restriction due to the diversity in their practices. That is what Indu Malhotra said. कितना convenient है मुझे अपने points रखना when I know that it is the argument between the judges. Is this very clear? ठीक है. Are you getting what I'm trying to say? Then it was also said that you need to understand. एक ऑस्ट्रेलिया का जजमेंट आया था 1950s में, जिसमें ऑस्ट्रेलिया में ये देखा गया था, it said that this doctrine of essential religious practice does not hold the test of time. It said, how would you determine whether the practice is essential or not? Because religion is such a subjective issue. Religion doesn't deal with rationality. It is more about your faith. And for me, it can be a practice. It can be a core practice. It can be a matter of faith. For you, it can be a superstition. मेरे लिए हिजाब पहनना बहुत जरूरी हो सकता है, मेरे फेथ का इंटीग्रल कंपोनेंट हो सकता है. आप कहोगे यार एक स्कार्फ ही तो है, 4 घंटे की तो बात है, उतार के आ जाओ बाहर जाना और फिर पहन लेना, क्योंकि आप उसकी ग्रेविटी को नहीं समझ पा रहे होगे शायद. आर यू गेटिंग माई पॉइंट? क्योंकि मैंने हिजाब का एग्जांपल दिया क्योंकि अभी करंट में चल रहा है. What I'm just trying to tell you is that religion is very subjective. It is based on individual's belief system. So many believe that something which is religious for me can be a superstition for you. Did you get my point, what I'm trying to say here? Is this clear for everyone? Okay. So this is what it is being said. Then it was being said that before Sabrimala, before you make a visit to Sabrimala temple, there is 41 days penance which needs to be observed. That is, austerity has to be observed. How you have to fast, you don't have to indulge in non-veg eating, you don't have to indulge yourself in sex, you don't have to indulge in any of the activities. So basically it is being said it is very difficult for a woman, because even menstruation, as we know, is considered as an impure activity, right? Which again is a very misogynistic statement, but yes, that is how it is being put forward. So it has been said that 41 days of penance needs to be observed, and it would be challenging for women to do that. That is the argument which was given against. Okay. There was one more argument which was given, which said that it is physically also very taxing, because you have to trek. It is at a certain altitude and you have to trek a lot. So that can be physically constraining for the women. Again, it is a very gender stereotyped argument, but then it is. Then there was one more argument that Sabrimala temple lies in an ecologically sensitive zone of Western Ghat. So if you will also allow women follower, right, then we have to make more arrangements. The arrangements have to be expanded, which can be challenging or threatening for the environmental sustainability. Is that clear? So these were the arguments which were being given. However, having said that, finally the judgment which was arrived at was that women was allowed the entry in the Sabrimala temple. Is this making sense for everyone? Is this clear? लिखो, arguments in favor of restriction of women. Arguments in the favor of restriction of women. Argument in favor, या पहले ऐसा करो, argument against restriction लिखो. Argument against, तो फिर एक flow बन जाएगा. Argument against restriction of women. Against restriction of women. First, banning entry was derogatory for women. Banning entry was derogatory for women. Banning entry was derogatory for women. Second, individual dignity of women. Individual dignity of women cannot be at the mercy of the mob. Individual dignity of women cannot be at the mercy of the mob. Individual dignity of women cannot be at the mercy of the mob. Next. Patriarchy in religion. Next point. Patriarchy in religion cannot trump or supersede. Patriarchy in religion cannot trump the freedom to practice religion. Patriarchy in religion cannot trump the freedom to practice religion. Next. Exclusion on the basis of biological and physiological factors. Exclusion on the basis of biological and physiological factors was unconstitutional. Exclusion on the basis of biological and physiological factors was unconstitutional. It violated the rights of women. Any exclusion on biological or physiological factors is unconstitutional, and it violated the rights of women under Article 14 and 15. It violated the right of women under Article 14 and 15. Next, the prohibition was a form. The prohibition was a form of practicing untouchability. Prohibition was a form of practicing untouchability, and hence against Article 17 of the Constitution. Hence, again, the Article 17 of the Constitution. Bracket में ये लिख देना. Although the dissenting argument was, just write it in your own words, although the dissenting argument was that Article 17 was with respect to caste. Although the dissenting argument was that Article 17 was with respect to caste, however, I actually want you to write about living tree doctrine, इसीलिए मैं ये repeat कर रही हूँ. However, it was refuted by quoting the doctrine of living tree. It was refuted by quoting the doctrine of living tree, where it was cited that Constitution, अब ये मत यार अपने words में लिख लो ना please. It was refuted by quoting the doctrine of living tree, where it was cited that Constitution is not a static document. That Constitution is not a static document, and the ambit of the provisions can be widened, ambit of the provisions can be widened, provisions can be widened depending upon the requirement, depending upon the requirement. Next. Next point. Prohibition is not an essential religious practice. Prohibition is not an essential religious practice, hence not protected under Article 25 of the Constitution. Prohibition is not an essential religious practice, hence not prohibited under Article 25 of the Constitution. Next. Fundamental right. Prohibition does not constitute essential religious practice, right? ERP. Hence not protected under Article 25 of the Constitution. Next. Fundamental rights are meant for the individuals. Fundamental rights are meant for the individuals and not for the deities or the idols. Fundamental rights are meant for the individuals and not for the deities or the idols. Arguments in favor of restriction on women. Next heading. Argument in the favor of restriction on women. Arguments in the favor of restriction on women, right? Religious communities should decide what constitutes ERP. Religious communities should decide what constitutes ERP. Else it would be termed as an act of judicio-papism. Else it would be termed as the act of judicio-papism. Next. Next point says, judgment is confusing diversity with discrimination. Judgment is confusing diversity with discrimination. That is, judgment is confusing diversity with discrimination. That is, different temples, I'll repeat, judgment is confusing diversity with discrimination. That is, different temples have different customs. Different temples have different customs. So what is being observed in Sabrimala, what is being observed, different temples have different customs. So what is being observed in Sabrimala is not discrimination but an act of restriction. Is not discrimination but an act of restriction. Next. Next. There exists historic origin of the restriction. There exists historic origin of the restriction as there was historic origin of the restriction as the entry of women in menstruating age group, the entry of women in menstruating age group was seen antithetical to the celibate nature of deity. to the celibate nature of it was seen antithetical to the celibate nature of the DT. It was not an act of misogyny. It was not an act of misogyny. Next. It was challenging for women to observe 41-day penance for the DT. It was difficult for women to observe 41-day penance for DT. It was difficult for women to observe 41-day penance for the DT. Next. The unique geographical aspect at the temple should also be unique geographical aspect at the temple should have been considered. The same point, it lies in the ecologically sensitive Western Ghats. So extending facilities for women can negatively impact the environment. So unique geographical aspect at the hill temple should have been considered. Full stop. Last point. Last point. In a pluralistic society like India, entertaining PILs, challenging various religious practices in a pluralistic society like India, entertaining PILs, challenging religious practices of various communities can cause serious damage to the constitutional and secular fabric of the country. Can cause serious damage to the constitutional and secular fabric of the country. Can cause serious damage to the constitutional and secular fabric of the country. Full stop. With this, Sabrimala topic comes to an end, right? Now, very quickly tell me, do I have a class tomorrow with you? कल मेरी आपके साथ क्लास है या किसी और बैच में क्लास, मुझे याद भी नहीं आ रहा है. Do I have a class? When I have a class with you now, I have to discuss hijab controversy. So anyway, today the case was going, जब मैं last आई थी तब तक hearing चल रही थी, तो देखते हैं क्या होता है. So we'll discuss on that premise. So we'll continue in the next lecture. So, but you need to tell me when do I have. Tomorrow I don't have a class with you, right? So I have a class with you then. इस week में है ना एक और class. So let us just wait कि High Court का क्या judgment आता है. And based on that, 19th को है I have a class with you. ठीक है, we'll discuss on 19th. So I'll just take another half an hour on 19th and I just have to discuss hijab controversy. So I'm just waiting कि थोड़ा और progress हो जाए High Court hearing में. So I would have something concrete to discuss. अभी तो सिर्फ एक side of the story सुना है. The person who is representing the case of the Muslim girls with respect to this hijab issue. ठीक है ना? Fine. So on Saturday in the beginning, first 25 minutes or 20 minutes, we'll discuss hijab controversy. And then I'll start with a fresh topic, that is population and associated issues. So after today, I would be requiring 3 more lectures and society would be done with. Okay, so I'll be meeting you guys on Saturday and we'll start with the population and associated issues topic. Okay, so I have given you enough questions today. Who is the coordinator? Ajay. Ajay, make that uniform civil code wala question, the factors which are inhibiting the government from implementing uniform civil code, that UPSC question as the assignment question. Okay, so I'll meet you guys on 19th Saturday and we'll discuss hijab controversy and I'll start with the population and associated issues. And we'll conclude today's lecture. ठीक है, चलो बाय पीपल, गुड नाइट।